Good morning, everyone, and thank you for joining us. This is the High Cost Team's High Cost webinar, Help Us to Say Yes. Just one point before we start. The Very High Cost Cases team and the Exceptional Complex Cases team have recently rebranded to the High Cost Family team. This is to make it clearer for everyone to understand what work we do and what our remit is, as in the past there has been some confusion. The objectives of the presentation is to understand the CCFS process, how 1 and 2 Council works, and understand common issues, where we will cover the case plan process, the differences between 1 and 2 Council, and at the end I'll go through hints and tips to make it clear for everyone. I'm joined today by Scott Baldwin, who's the Chief Executive at St Mary's Chambers, who is a member of the Barristers Clerks Management Committee and is the Chair of the Family Division. I'm also joined by another fees clerk, Chris Ferrison, who is a Senior Fees Clerk at one of the largest family chambers, One GC Family Law, who specialises in high cost family council fees. I'm also as well joined today by Rebecca Bidwell, who is a law cost draftsman and director of Bidwell Henderson Cost Consultant, where she specialises in high cost family cases. From the LAA, I'm joined by Anthony Leal, who is the head of the high cost family team, who will be doing the main body of the presentation, and who is also a solicitor. And also John Chapman, who is a member of the high cost family team, who will be dealing with the questions. It's a quick thing, just go through the acronyms that will be discussed today. We've got the FAST, which is the Final Assessment Streamlining Tool, CCMS, which is the Client Case Management System, CCFS, which is the Care Case Fee Scheme, and I previously said VHCC and ECC and HCF, so I won't go through that again. Obviously, we're the high cost family team, and the CAF, which is a council acceptance form. That's all from me for the introduction. I'll pass you over to Anthony, who will start with the main body of the presentation.
Hello. For this part of the session, I'm going to take you through the life cycle of our high cost case plan, starting with the registration or the notification that you send to us at the start of the case cycle. In single counsel cases, that happens at the point where you identify a case is high cost. That means at the point where you think that the case is likely to or has exceeded £25,000. You need to sort of tell us that that's the situation. In single counsel cases, the default position is that if you tell us the case is going to be high cost, we will treat it as though it's under the events model. The only way to, if you think that the case is going to exceed £25,000 based around exceptionality, i.e. that the costs are going to be more than 30% of what you would receive under the CCFS scheme, that application for exceptionality needs to be made at the outset. So when you tell us, by way of a general case inquiry, that the case is going to be high cost, you then make that application at the same time. In a 2 council scenario, the point of registration is really dependent upon the application for prior authority for Queen's Counsel, or for 2 junior counsel, or even Queen's Counsel and junior counsel. I should mention at this point that the prior authority only covers counsel. The application for prior authority is not in relation to solicitor advocates per se. That's not to say that you can't use solicitor advocates. It's the fact that for the purposes of prior authority, you can get the authority in place. Once that's in place, if you wish to instruct or use a solicitor advocate, that's fine. So if you've got a solicitor advocate who wants to stand in place of junior counsel, once the authority is in place, that is absolutely fine. In terms of the authority itself, when it's granted, you will receive a note from the LAA. It will come by way of an instant message, by way of a provider ad hoc notification, telling you that you've got that authority, but also telling you what it's restricted to. Almost every application for prior authority will be restricted. Usually in care proceedings, for example, it's restricted to the fact-finding hearing. And it's really important that you are aware of that restriction so you don't go beyond it. I'm going to bring in Rebecca and Chris and Scott at this point, just for some reflections around the registration process, the notification process, and how that impacts. Rebecca, if I can turn to you to start with your reflections around application and notification and the importance of making sure you are top of your costs. I think that's where you're.
Absolutely. So first point I've got for you is a tip for providers, really. If you are seeking to register on the hourly rate scheme rather than the CCFS or to council cases, one thing that we do, because obviously when you're making that request to prove that your costs and your case is exceptional, if you're finding that you can't provide that justification well within the 8,000 character limit, one thing that we will do in that instance is in the application, we will actually ask that the case plan notification be opened up, so you can set out the brief details of your case and the exceptional circumstances, but then you can actually follow that up by providing the LAA with a lot more information in the case plan notification area. Another thing that I think is really important when you're looking at the to council side and the prior authority aspect, we've seen quite a few cases recently where, as Anthony's just said, you'll have a potential situation where a request has been made for to council, for example, for the entirety of the case from that point onwards, and the notifications come back and it's been misinterpreted. And the fee earner has then gone to council's chambers and let them know that they've got authority for to council for the entirety of the case. And in actual fact, they've been limited to, for example, an appeal hearing. So I think it's really important to check those notifications, because that can be quite an easy mistake to make, but also a very, very expensive one. So I think that's probably my two top tips for that section.
Scott, Chris, do you want to come in?
Well, yeah, all I can follow up on that is from what you said and what Rebecca said, exactly that. I've had a few cases recently where I've got prior authority. The fact finding has actually happened, but the solicitors have said, well, we've got prior authority up to the welfare or final hearing as well. Because within the legal aid certificate, the scope will always say up to and including the final hearing, but it's only in relation to a junior only certificate. The best way of actually avoiding this is exactly what yourself and Rebecca said, is that the CCMS notification specifically tells you what you're covered for. From my point of view, that is the most important document that I require to make sure that there is funding in place when it's a to council case. Because as Rebecca has said, it can become a very expensive mistake, which obviously we want to avoid, because I want the solicitor to be paid, I would want to be paid, and I don't want to run into those sort of problems. So that's what I would say on the back of obviously yourself and Rebecca have obviously already mentioned, but I don't know if Scott's got anything to add to that at all.
I think in general on high cost cases, one of the things that I commonly see is that solicitors don't often appreciate that we have far less access through CCMS to the information that they have. So all we can see are information relating directly to council. So I can see what costs have been allocated to council, but I can't see the total costs on the case. I can't see if the cost limit's been increased. I can't see if it's been registered as high cost, and I can't see any of the correspondence between solicitor and LAA. So that we do rely on you as council and council's clerk, but for you to act as a conduit for that information from the LAA to us, especially when it relates to our fees. And I think communication in general for VHCCs is really important. If you involve council and the clerks at the early stages, we can assist with planning, we can provide you with cost estimates and make it a lot easier for you to put your case plans together initially and registration initially.
Thank you both. I think I also want to mention at this point, I think it's worth highlighting that the legal aid certificate that you receive carries, of course, the scope of the proceedings which are covered by legal aid, but that is separate to the prior authority. So when we've granted prior authority, the prior authority will actually appear on the certificate, simply noting that it's been granted. What it doesn't carry is any limitation. So whatever you see in the way of the prior authority is separate from the actual scope of the certificate. That's the really important part of this process. So the thing to look out for, as I think we've all really reinforced, is the notification from the LAA at the point of grant of the authority, because that carries a limitation.